Hey, it's Mahoney coming to you for another Tuesday night tip. Happy Tuesday night. So Mahoney had some big announcements. We purchased a building in downtown Freeport that we're in the process of rehabbing. We're going to start our plans. We've met with the architect. We are meeting with builders. We're meeting with contractors, all the stuff. Hopefully construction will get going on that project in the next couple of months. And then our Rockford office opens up July 1st, and we put a link up to that. So we're very excited that we're now going to have a presence in Rockford. We do a great deal of stuff over in federal court over there, so it's going to make access easier for our clients and for us. So tonight I wanted to talk to you about the difference between a personal injury case and a workers' comp case and how they interact a little bit. So a personal injury case is anytime one person is injured by another person or entity, corporation, partnership, whatever, and that person owed them a duty to not do whatever activity ultimately injured them. So the easiest one is a car wreck. If you cross the center line and hit somebody on the other side, you owed them a duty not to do that, and so now you were negligent, and now therefore you can be sued in a personal injury. You ran a stop sign, same type of thing. And there's all types of them, right? There's products liability, there's medical malpractice, there's premises liability, there's all types of personal injury cases that are available depending upon, but you have to owe a duty from one person to another and have breached that duty, and that breach causes some type of injury in order to have a personal injury case. Now, a workers' comp case is when an employee is injured within the scope of employment. And the idea behind the workers' comp statute was, it's really called workers' compensation statute, was to try to simplify the process. That was the initial idea. Rather than have workers sue their employers in a regular personal injury case, we're going to streamline the process. So if you're within the scope of employment and you are injured, then your employer is on the hook for your injuries. And what they did is they number one, they took out fault. So it doesn't have to be that the employer did anything wrong, or it's just if you're injured while at work, then the employer has to pay. Because they took out fault, then they lowered the amounts that an employer has to pay. It's not based on the system in a personal injury case. It's based on a system that's created by a statute. This is all created by the legislature. The legislature tomorrow could get in the state of Illinois could get together and decide there's no more workers' comp law, and the workers' comp law would be gone in the state of Illinois. So this is a legislative situation, whereas personal injury stuff, it has a legislative component to it, but it comes from common law. This is something that was back in Old England. Started out with property damage, my tree falls on your fence kind of thing. So if you're injured within the scope of employment, then your employer has to compensate you for that. If you can't work, then they have to pay you what's called TTD, temporary total disability, which is a percentage of your average income. And they have to pay that for a period of time until you, in fact, can get back to work. Once you can get back to work, then your case is valued based upon how permanent your injuries are. And they look at those permanencies and they call them what percentage of a man, you can tell that the statute's kind of old, what percentage of a man have you been injured? So like if you lose a finger, your finger ends up like this, then there's actually calculations in the statute. So it says one finger equals so many weeks, and it's based on the finger. Is it this finger or is it this finger? No, I didn't give the wrong finger. Different fingers constitute different things. A toe versus a leg versus half a leg versus an ear versus eyesight in one eye versus eyesight in both eyes. All of those things work out to a number of weeks. Percentage of a man equals a number of weeks. And then the number of weeks is based upon your average pay. So if you lose something and it equals 50 weeks, then they take your average pay per week, they multiply it by 50, and then that's the amount of money that you receive. So there's a formula that's used, and all of that is designed to try to make it simpler. It's a statute that has run into a lot of struggles, both by employer and employee beliefs at this point. It's become a little bit difficult, but that was the idea. Now, can these two things interact? Yes, they can. Can you have both? Sure. If within the scope of employment you are driving and then you are hit by somebody else, you now have both a workers' comp case and a personal injury case. You have both. You have a workers' comp case because you're within the scope of employment and you've been injured. So they have to pay you TTD, and then they have to pay you based upon a percentage of a man. But you also have a lawsuit against the person that struck you in the other vehicle. And so you sue them, and if and when you recover, the workers' comp gets to get paid back from the money that you received from the vehicle. So you'll hear something called a workers' comp lien. Somebody will have a personal injury case, and they're trying to settle the case, and they'll say, I have a workers' comp lien in this case. That means that they were actually injured within the scope of employment. That has nothing to do with fault. So the employer has already paid them for time off work and compensated them for their injuries. So now the employer gets to get paid back based upon that. A lot of times in workers' comp, there's an issue of, are you in fact within the scope of employment? You know, if you're running to Starbucks, that could be considered a frolic and not necessarily within the scope of employment. Driving is a big one. Is driving part of your job, or were you driving to your job? So that's one of those things where you can have a lawyer and help decide those issues for you. Workers' comp also doesn't happen in a regular courtroom. You go in front of an arbitrator that is selected by the state. And so like if you're in my area, you go to the State of Illinois building in Rockford, the Zeke Georgie building, and then that's where you appear in front of the commission, the Workers' Comp Commission, and they decide your workers' comp cases. It used to be that lawyers did both of those kind of routinely. That still happens, that lawyers will do both workers' comp and personal injury, but it seems like more and more they kind of do one or the other. Because if you do workers' comp, you have to do tons of it. It's one of those things, it's like tax, it's like bankruptcy, it's like DUI, where it's kind of like almost all of what you do, or it's a big portion of what you do. And so it's not as often as it used to be that if you have a case where you have both a workers' comp and a personal injury, that you'll have the same lawyer. A lot of times you might have two lawyers. You'll have a workers' comp lawyer and a personal injury lawyer. But the fees tend to basically work out to be the same because the workers' comp fee is set by the commission. It's set by the arbitrator. And personal injury fees are based upon contract. They're a third or 40% if you go to trial, things like that. So even though you have two lawyers, your cost of those two lawyers tends to turn out to be about the same. So I hope everybody has a great Tuesday. I'm only licensed in the state of Illinois. I am not here to give you legal advice. This does not create an attorney-client relationship. Please see a lawyer in your area. If you want to see me, I'm at Mahoney.com, or as you may have seen in the commercials, which are now airing, Mahoney'sGotYourBack.com. Thank you guys. Have a great Tuesday.